Hi, we are live. Welcome to Speaking with Conviction, everyone. I'm Diane, and I'm joined here today by Jane and our lovely guest, Kate Judson from the Centre for Integrity in Forensic Science. So thank you so much for joining us, Kate.
Hi, thank you for having me.
Yeah, we're really pleased to have you. Right, so before we begin, I just wanted to ask you, because we did ask you before we came on, but I wanted to ask you something that's happened recently with the Making a Murderer case. There was a filing on our docket, on the docket. It's mine now. And it said sua sponte. So for anyone who is wondering what that means, could you explain what to you it means, please?
Sure. I might be getting the Latin wrong, but sua sponte means by oneself. So usually what what sua sponte is when a judge does something by themselves, not on another party's motion. So they do something without a lawyer for one side or the other asking them to. They choose to do it themselves.
Right. Okay. Well, that clears that up then. Yeah.
Usually you see it like judges might make a decision to not present a piece of evidence to the jury, or they might decide to change somebody's bond, not on the motion of one of the parties.
Right.
So that's what it might be then, because it might be he's deciding not to present that to the judge because he can't.
Possibly.
I don't know, but
we'll soon find out some more information, I guess, because it usually gets released in one way or another, doesn't it?
Yeah, I don't know about this issue specifically, but generally, sua sponte is when the court does something by itself without someone advocating for it. Yeah, and it can be controversial sometimes. Sometimes parties are upset when judges do things sua sponte.
Oh, okay. Well, thank you for that anyway, because there's a lot of people who will come here who follow Making a Murderer as well, because there's a lot of us who follow that case. So I just want to say hi to everyone who is here so far. So hi Linda, hi Jay Jax, hi Eric and Being Green, and anyone else who I've missed. Yeah. One of the other things that we just want to say is that we lost a close friend to us in our community, Eric Ose. He was a really big advocate in our community, so we've spoke about him a lot since we've been here. I just wanted to say to anyone who is watching, I've put his link to his YouTube channel in our description, because he was a great advocate for the innocence movement, so I've put that in the description.
Yeah, and if people, his work is still really important. So if people want to, if they're not already subscribed to his channel, and you can still go on and watch his videos, because it would be great if people still supported his channel. Because I do still share certain videos, and just please still support his channel, because he's a big loss to this community, and we're all really sad. So it's hard.
So we've got you as our guest, Kate, so let's talk about you. So do you want to tell us a little bit about yourself and your career background and how you became involved in the CIFS?
Sure. So I started my career as a public defender, and I was a public defender for 5 years. Most of that time I spent doing felony cases, and towards the end, mostly more serious felonies. And then I moved to Wisconsin. I started to work for the Wisconsin. Well, initially I worked for the Innocence Network, which is the.
This is what got our t-shirts on.
Yeah. That's right. Yeah. So the group, the International Group of Innocence Efforts, right? The kind of confederation of innocence efforts, and I think there's nearly 70 in the group now. I think it might be something like 67. And I worked for the group that supported the Innocence Network. So I was a member of the network support unit, and I did technical assistance, helping innocence efforts with their litigation, especially related to forensic science issues, lots of science-dependent cases. Science-dependent are cases where the entire case rests upon an expert's opinion. So a good example of that is an arson case. If there wasn't an arson investigator saying something was arson, there wouldn't be a crime, there would just be a fire. If there wasn't, child abuse is another, certain kinds of child abuse, right? Because some children who are abused can tell you that they've been abused. But in many others, it's only the expert's opinion that is used to show that something is abusive, right? And if they don't show that, then it's an illness or an injury that's accidental. And then I moved to the Wisconsin Innocence Project, where I worked until 2019. And in 2019, I started as the executive director of the Center for Integrity in Forensic Sciences.
And here we are.
Here we are.
Yeah.
So how we found out about the CIFS is our passion for wrongful convictions, which started with Making a Murderer. And from that, we came across Dean and Jerry. And then from Jerry's tweets, that's how we came across the CIFS. So have you seen Making a Murderer, Kate?
I have seen it. Yeah.
Can we ask your opinion on it?
You can. Some of the lawyers on it, of course, are my colleagues. And Keith Finley in particular, I worked with for many years, and he continues to be the president of our board. I should let you know that I didn't have any involvement in Stephen Avery's either of Stephen's cases, and I really most of what I know about the case is limited to what I saw in Making a Murderer.
Yeah, that's fine. We thought we'd ask anyway while you were.
Yeah, I'll answer if I can.
Yeah, and just basically what, like forensically, what issues did you see there?
Yeah, so one of the things that that the center is really concerned about, and that we advocate about frequently, is there should be quality standards in place for forensic evidence, and those standards should be in place regardless of whether the defendant seems particularly guilty or particularly innocent. We believe that everyone deserves a fair trial with fair evidence correctly presented, not just people who seem like they might be innocent, because of course we don't know until after the trial. And even during post-conviction, you might, even after somebody has been convicted and adjudicated guilty, again, like, we are advocating that folks get only good forensic evidence that's used against them, only really solid, well-grounded forensic evidence. So one of the things that I remember from Making a Murderer, and it's been several years since I've seen it, but one of the things I remember is that there was a question about DNA evidence, and there had been an error in the testing, right? And that evidence was presented anyway. That's a serious issue. If the evidence can't be duplicated, if it can't be verified, if there's a known error in it, if there's known contamination, then those results are not reliable.
And who enforces that though? Like, because obviously it wasn't enforced then. So like, who are the people who should be enforcing that?
Right. So when we talk about wrongful convictions, especially, but convictions based in forensic science, they can. When you look back and do the analysis of how the wrongful conviction happened, it can happen in a variety of places, right? So it can happen if you start all the way back at the beginning of the case. It can happen during early investigation. You can have error in early investigation. You can have error when the case is presented to, depending on what state you're in, a grand jury or a judge for charging. You can have error because the lawyers don't, defense lawyers in particular, don't do a good enough job strongly advocating for their client, zealously advocating for their client. That's a legal phenomenon called ineffective assistance of counsel. And then you can have error because prosecutors present evidence that's false. Either they do it knowingly, right, attempting to make sure that they secure a conviction. They do it accidentally. They listen to experts who are telling them something that's not true, whether that's a known untruth or just a mistake. And this is a place where we've really seen some problems, is judges are often reluctant to keep out evidence that is presented by the prosecution. And while there are plenty of competent, intelligent jurists who understand the science and apply the rules appropriately, there are also some who make mistakes, and or who are influenced by, as we all are as human beings, influenced by prejudice and bias. And so judges sometimes are reluctant to keep out a prosecutor's evidence. And that's also how a lot of bad evidence comes in. And then when we're talking about science, not so much a case of like known error, right? Like known contamination in a DNA sample, but a forensic science discipline that hasn't been well validated. Another problem is the law rests on precedent, right? So in court, if something has been admitted into evidence in another case, it's more likely to be admitted again. And that is, of course, the exact opposite, right, of how science works. Science tells you that if something new comes along that shakes that is reliable, that shakes your belief, you should update your belief, right? And so that's another place where we see error come in. So it's a hard, I rambled, it's a hard question.
No, that's brilliant, yeah.
It's a hard question to answer, right? Because it can come in all these different places. And that's often why when the center works on a motion, right, when we're asking for a new trial for a client, we often file these motions that have all kinds of different grounds, some of which might seem like they're not directly related to the scientific issue, like for example, ineffective assistance of counsel, right? But the way that the criminal justice system the criminal legal system has decided that we are going to enforce these rules is with defense counsel. So if defense counsel fails to fulfill their constitutional role, then a person doesn't get a fair trial.
Yeah. Which is the ineffective assistance. Yeah. Gosh, it's so complicated, isn't it? That's why these things take so long as well. Like, because you have to involve all of those different things. Like, I'm guessing if there's a lot of complex things involved in a case, like a judge has to sit through and read through both sides of the story, don't they?
Right.
So, is that the reason why it takes so long?
Well, if we're talking about a trial, those don't take as long as some of these post-conviction cases. But once somebody has been convicted of a crime, they have no right to a lot of things that they have a right to before they're convicted. So in the United States, of course, if you're accused of a crime, and in many other countries, if you're accused of a crime, you're presumed innocent until you're proven guilty. And with that innocence comes some rights. You have the right to due process of law. You have a right. That means you have a right to a fair trial. You have a right to a lawyer. And after you have been convicted and exhausted your appeals process, you don't have a right to a speedy trial anymore, and you don't have a right to a lawyer. So sometimes the reason why, especially these post-conviction cases, take so long is that judges aren't really obligated to hear them in many jurisdictions. The person doesn't have a lawyer, so they don't have somebody to walk them through the process, and they're not entitled to a lawyer provided by the state anymore. So they might that might be part of the delay. It often is part of the delay. Here we have an additional problem, which is that in the 90s there was a law signed called the it was called AEDPA. Right?
Yeah. We all know that one, don't we, folks?
Yes, yeah, right? Because you're following these wrongful conviction issues, right? But it strictly limits the amount of time you have to bring a post-conviction challenge. So that has also been a serious procedural barrier, a real hurdle for clients to get over, for people who've been convicted to get over.
No. Well, tell us a little bit about, because with regards to the CIFS, I was looking on your website and you've got like a section that talks about the goals of CIFS. And one of the goals is under the legislative section. It speaks about making crime labs independent.
Mm-hmm.
So how are they funded and set up at the moment?
A lot of different ways. Many crime labs, though, and this is the thing that we're most concerned about, and this is a really intractable problem. I can't say that we've made real significant progress on this particular goal. When I first became a lawyer 15 years ago, people knew it was a problem, and we've been working on it since then and before then, and still know very little progress. But the way that crime labs started is many of them began as an arm of the police. So they were housed in law enforcement agencies. Many police departments had a crime lab. The FBI has a crime lab, right? And so what that can make analysts prone to is something called a cognitive bias called role effects bias. So that means that if you see yourself in a particular role, you're likely to act in conformity with that role, or you're likely to be biased to act in conformity with that role rather than challenging it. And so what that means is if you see yourself as an arm of the police, right, if you're part of the police department, you're more likely to do what your colleagues want you to do, whether you are doing it consciously or not.
Right, okay.
So how did CIFS come about, Kate?
So the organization was founded by three of the lawyers who are primarily featured in Making a Murderer. Keith Finley, who handled the post-conviction action for Stephen Avery, and then Jerry Buting and Dean Strang, who represented him in his 2005 trial. Was it? Do I have the date right?
2007. The crime took place in 2005, but the trial was in 2007. Six. Not Brendan's was 7. Somebody in the audience.
Okay, well, I'm sure it's known, and it's not a critical part of the founding of the organization.
Yeah.
But they in 2017 got together and had the idea to create an organization that was primarily focused on making sure that the science presented in courts, particularly criminal courts, was valid and reliable. There wasn't before us, and we're still, as far as I know, the only ones who are exclusively focused on that goal, and who work nationwide and, in fact, internationally to challenge practices that lead to the admission of incorrect, unvalidated, unreliable science in criminal courts, especially.
It is 2007. Yeah. People are saying it's true.
Yeah.
Yeah.
I'm sure. I'm not surprised that somebody knew.
Yeah.
Yeah. Has anyone got any questions out there?
Researchers in here who are watching.
What you say?
I'm saying we've got some great researchers in the chat that are watching.
Yeah. They really get stuck in.
Yeah, they know everything. I know some things, but a lot of it goes way over my head. They're really good.
It's amazing what people have found. I'm not as involved in it as I know you all are, but I mean, it's been really amazing to learn about folks who have gotten together to research some of these old cases that have resulted in a wrongful conviction or have otherwise had something untoward going on during the trial.
Well, there's a lot of stuff going on with Tiger King at the moment. I don't know if you saw that. There's a group of people, and I think one of the researchers for that is here. I've seen.
Yes.
So that's really in the media at the moment with with Don Lewis going missing. He was the guy who went missing from Tiger King.
Kate, we've got a question for you. Do you think that Stephen and Brendan are innocent?
I don't know enough about the case. I have real questions about what I do know is about the forensic science.
Yes.
I have real questions about the way that certain things were presented in that case, and the way that the different things that experts relied upon.
Yeah. Just while we're at this point, if there's any other, can't go back up. Why can't I go back up? Hold on.
There's another section while you're just looking for that, Jane. There's another section in the legislative goals bit about educating the public about like knowing the ins and outs of like what I don't know how to explain it properly as like because it's really fancy wording, but so do you want to tell us a bit about that? Like how you go about, like, you know, people like me, for example, who don't know the ins and outs. How would you go about doing that?
Absolutely, yeah. So it's a really important goal of our organization, and primarily, especially now that we're in a global pandemic, we've been doing that by having educational materials out on social media and talking about different cases that are in the news. We want the public to be good consumers of the criminal legal system, to really understand the ways that things can go wrong and the importance of their role, either as a member of the public, because you have influence over your local law enforcement agencies, your local prosecutor. You can you have the ability to vote for somebody who you think is going to do justice. You also are, if you are a person who could get called to sit on a jury, you have a very sort of immediate responsibility to see that justice is done. So we want to make sure that people are educated about some of these issues that might arise, and that they look at them with a critical and a skeptical eye, that they don't say, this is being presented to me by the state, so it must be true. Or even this is, you know, generally we're talking about wrongful conviction. So so in those cases, typically the state is in the wrong, but we also want them to look critically at any science that's presented by the defense. We want people to be educated on these issues and thinking them through.
Yeah.
And sorry, Sanjay, you go on. I've got big mouth today.
A couple of questions once to scroll down. Linda's asking, from what you do know about the case, do you think they need Stephen and Brendan?
Yeah, I mean, from what I've heard and you know what I've seen, again, definitely not an expert, and I'm sure that everyone else on this stream knows far more about it than I do. But yeah, I have some real concerns. And when it doesn't appear that somebody has gotten a fair trial, it is absolutely appropriate to give them a new trial. They absolutely deserve a new trial. If evidence was presented at someone's trial that's false, if someone gave a false confession and there's good evidence that there's a false confession, yes, absolutely, people deserve a new trial in those circumstances.
Sorry, I've just had a random question pop into my head thinking about that, actually. In terms of, like, if you had two separate people tried for the same crime, would you think it's unusual that there's two different theories presented and they're both convicted on different theories?
I don't know how common or uncommon it is. It is something that I've seen before in wrongful conviction cases. But often my sample size is, my sample that I'm looking at is skewed, right? Because most of the time when we're looking at cases, something bad has happened to get it on my desk. But yeah, no, that's something that I've seen before. I have real questions about it.
Yeah, I think we all do on that sense. Go on, Jane, sorry.
Smart Duck is asking, what is the general opinion within the DOJ and with lawyers in Wisconsin over the Stephen Avery and Brendan Dassey cases?
I think it's all over the map, the way it's all over the map with the general public. I don't have really any direct connection to the DOJ, but I live in Wisconsin, and my experience is that lawyers are just all over the place about it.
And Eric is asking, does Kate think prosecutors should not have immunity and should face stiffer consequences for their actions if they are found to be dishonest?
Yeah, I think there really needs to be some kind of repercussion, especially when there's deliberate withholding of evidence, or when there's just dishonesty, I guess is the word that I'm searching for. Mm-hmm. As far as I know, there's only been one example of a prosecutor who's faced criminal consequences for withholding evidence, and that was a prosecutor in Texas who later became a judge who prosecuted Michael Morton's case. He later was given a sentence for his misconduct, and I believe disbarred, but he served something like 10 days in the county jail.
Oh.
I mean, it's nothing compared to Michael Morton's 30 years behind bars. Yeah.
10 days.
I think it was something like he was sentenced to 30, and I'm not sure. I don't remember all the specifics of it, but Yeah, he received a very short sentence to begin with, and he served even less of it.
Wow. That's really sad, isn't it? I mean, it's better than nothing, but it's still really sad.
Well, I think what can sometimes be ignored in these cases, although I suspect that you and your audience are not ignoring this important issue, which is that in some of the cases I work on, there's been no crime committed at all, right? Somebody is a caregiver for a child or a person who is infirm, and the person dies or suffers some kind of an injury, and it's later found to be an accident or the result of a disease. And in those cases, or there's a case in which there's like an arson case in which it's later found that the fire was totally an accident, not intentional. And in those cases, there's no crime, right? But in so many others, convicting the wrong person means that the actual perpetrator of often a very violent crime is free to continue to commit crimes.
Yeah, exactly.
Yeah. You see all too often.
Yeah.
And
in the first case.
I'm sorry?
In Stephen Avery's first case, the real perpetrator, he was still out there.
Yeah. And he can recommit a crime, didn't he?
Yeah.
It's awful. And that'd be something to, I mean, I don't know if there's any studies being done on that kind of thing where they would like find out how many more crimes wouldn't have been committed if they would have got the right person in the first place, which is, it makes you shudder to think that.
I'm only aware of one study that's been done on it, and it was only done in one state, but they found that I might have to see if I can find you the information after we're off. But
yeah, that'd be interesting. Yeah, thank you.
I think what they found was that on average, perpetrators went on to commit 1 point something additional crimes, right? So at least one more violent crime.
Yeah. That's still... Okay. And we're back in action. We can see you again now. Hi, Donna.
Our questions.
What you said, sorry?
A couple more in the chat, so do you want me to? Because I don't recall. How do you advocate for using reliable signs in court? Have you tried to hold seminars to educate judges? If so, how was the reception?
Yeah, so we are actually currently working on judicial education. We do a lot of lawyer education. We train both prosecutors and defense attorneys on issues related to forensic science. The reception has been good. I mean, people are sensitive about having their work challenged. It's normal. It's a human response, and we all just need to get better about accepting feedback like that. But I think most people know that there are problems that need to be solved. I think that opinions are all over with respect to which problems are the most serious and how to solve them. We also advocate through the use of amicus briefs, which if the audience doesn't know, those are briefs filed usually by organizations in a case in which they have an interest but are not a party, don't represent somebody who's involved in the case. So, for example, there was, I'm trying to think of the most what the most recent one we filed is. There was a case in Mississippi where we filed at the end of May to support giving a new trial to a man who had scientific evidence that was inaccurate presented at his trial. So we didn't have any stake in the case as an organization, but as an organization, we believe that people deserve reliable and accurate forensic science. So we wrote a brief to the court explaining that, right? So we do a lot of that. And we also do some direct representation.
And sorry, Jane.
Go on.
No, carry on.
So it's not just in Wisconsin, you have cases, it's all over.
We have cases all over. Mm-hmm.
Yeah.
Yep. And we consult on cases in other countries too. We've consulted on cases in Canada and Japan, other places.
Wow. How do you get around that? Like in terms of like, because you know, like how you have to go from state to state and like, because you have to be practicing in that state, don't you? So how do you overcome that in different states and then different countries as well?
Yeah. So when we directly represent a client, we work with a local attorney. So we would be always the second sort of law firm on a case. I would be the second lawyer.
Yeah.
And we're admitted, I'm admitted what's called pro hoc vice, which means that another lawyer vouches for you and you agree that you're only practicing for the purposes of this one case or these limited cases in that state. You're not intending to practice there forever. Yes. But the other thing is, one way to kind of imagine it or conceptualize it is we're able to consult on so many of these cases because science is universal, right? The system of law might be different in each state, in each country, but what is good science doesn't differ when you go across a border. So while we might not be in front of a judge in another country, right, we would still be able to advise the lawyers about the way that they might think about presenting their case or how to understand the scientific literature or how to talk to their expert to come up with an effective argument on behalf of their client.
So in terms of like junk science, like what to you constitutes as junk science?
That's something that's always evolving, right? So 20 years ago, people were very accepting of bite mark identification, right? Matching a mark found on a body to somebody's dentition. And in fact, there are people who are still actually being accused based on bite mark evidence. But now so many more people understand that it's junk, that there's no reliable way to match somebody's dentition with a bite on their bodies. And you know, there are other famous ones. Hair comparison analysis has been shown to be unreliable. CBLA, comparative bullet lead analysis, has been shown to be unreliable. That's matching a ballistic found at the crime scene with a box of ammunition. There are some more esoteric ones. So I would say that there's something called blown film analysis, which means basically matching plastic bags with other plastic bags. So you find a plastic bag at a crime scene, you go to your suspect's house and you say, this plastic bag matches the roll of plastic bags that's been found at the suspect's house. Yeah, and that there's just really reporting that. Yeah, no, it's a huge problem.
That just seems like somebody's gone, oh, you've got the same plastic bag as that seems really random.
You know, there's a kind of famous case about it where in which the state was saying that the bag used at the crime scene matched the roll of bags found at the defendant's home. And what was astounding about this is they found a way to sort of match the striations in the bag up to say that they matched. But the bag that was found at the crime scene was actually of a completely different size and type than the ones. I mean, it's almost unbelievable that these things get admitted. So really, so many of these pattern analysis disciplines that do what's called individuation, saying this shoe print matches the defendant's shoe, this bite mark matches the defendant's teeth. With very few exceptions, that is not reliable.
Yeah.
So with regards to like forensic experts going to court that are being used, how do we ensure, like, if people that have seen like the Innocence Files, you've got the bite mark analysis expert there, he and like the Dwayne Deavers, have you seen these cases, the blood splatter analysis guy, Dwayne Deavers, he was in the staircase and they were both found to, well, let's just say not be
unreliable sources.
How do you ensure that the experts that are coming are reliable, are coming to testify? How do we ensure that they are reliable?
Yeah, I mean, that's another question that's complicated. It has a number of factors, right? So ideally, what we want prosecutors not to bring cases that rely on this kind of evidence that has been shown to be unreliable, or these experts that have been shown to be unreliable, right? That's a perfect world. The cases never get brought. Those experts don't get called. Those experts aren't consulted. Those experts are never called at trial. And in fact, there's never a trial, right? Because the person isn't accused based on shoddy evidence. If that doesn't happen and the prosecutor is relying on evidence that is junk, right, then we hope that we hope as a society, but as an organization, what we advocate for is that every person have a vigorous, zealous defense, that every person have a lawyer who is working hard for them, standing up for them, aggressively fighting junk science, aggressively fighting bad evidence. And that includes things like making motions to the judge before trial to keep certain evidence out at the trial so the jury never hears it, right? And so what we need to make that work is not just zealous advocates for the defendant, but also courageous judges who can say, I understand the state is asking me to do this. I understand the other judges have done it before, but I'm not convinced and I'm not going to do it because I'm not going to be part of perpetuating this kind of, flawed forensic evidence. So we hope that we hope that we can, and as an organization, we advocate for those 3 prongs to be met, right? That first, we don't rely on bad science. Second, when someone has relied on bad science, that they receive a good defense, and that when they do bring that evidence in front of the judge is willing to step in and not consider and not allow juries to consider evidence that is unreliable. And frankly, if those things work well in tandem, if all of those prongs are met, I think we really go a long way toward protecting innocent people and making sure that we don't imprison innocent people. But where we run into problems is where parts of that, you can kind of think of it as a stool, right? Where we run into problems is where legs of it are removed.
Yeah. Yeah, absolutely. Have you found any questions, Jane?
Yeah, there was right. So Alice, so a lot of making a question.
I know, yeah.
Alice is
asking. I'm so sorry. I don't mean to interrupt, but I completely forgot in my discussion of all these lawyers. One of the most important things, we hope it doesn't get there, but if it does, one of the most important things is jurors who are skeptical, who say, that sounds bogus to me. I don't think that's right. And that's a really important part of it. Although I have to say it's so damaging to people and their families and their communities and their reputations and all sorts of other things to be accused. So we really, really hope that people aren't falsely accused and don't go on trial and have to, show. Technically, they don't have to prove their innocence, right? But often it feels like you have to show that you're innocent to win at trial. And we just hope that people aren't put in that position because we have better science and better law enforcement.
Yeah, I think watching the Innocence Files as well, I mean, like, you can see the impact that it has on people's families, and that's just like on all of the families, the victim and on the person who's been wrongfully convicted. Like, it's just heartbreaking.
Well, how many cases did that Mike, the bite mark analysis, how many cases did he go to court and testify at? And
there's loads, wasn't there?
Loads.
I don't remember the exact number, but many.
Yeah. Many.
Mm-hmm.
Yeah.
Yeah.
And then it's like shifting away, though, isn't it? It's like if you've got a person who's got the mentality who's just like, no, this is my opinion and I'm not going to move away from it no matter what. Like, you are going to come across stubborn people like that. I mean, I'm sure everyone will know that we've got people like that in the Making a Murderer case, but, it is what it is. You just got to...
The question someone was just going to ask, because Alice is asking, what did you think about the Ken Kratz press conference? So when...
Oh, right, yeah.
Before the trial.
And you're talking about the prosecutor went on television and gave a bunch of lurid case details.
Yes.
Yeah. There are ethical rules that lawyers are supposed to follow, particularly prosecutors, about giving evidence to the press, especially evidence that might taint a jury pool.
Yeah.
It's not allowed. It's really unethical. Nobody should be doing that. And I think there's a little bit more leeway for defendants to talk to the press, because if you're accused of a crime, we don't curtail your freedom to proclaim your innocence. But for prosecutors, they should not be going in front of the press and in front of the public and giving information that might taint the jury pool.
Yeah, and that's exactly what it did. That's exactly what it did.
Hold on, just Linda's saying that she had a question. I think I missed it earlier as well. So is this it, Linda? How much weight does that have the courts? I mean, Brendan had 250. You would think that would have a lot of puns. Is that your question? Have we missed some of the context of the conversation?
I thought I'd read that. Must be another question.
Hold on. Is this a question, Linda? Oh, it is a question. How much weight does that have with the courts? I mean, with Brendan had 250. I don't know what you mean. I think we might have missed some of the context, Linda. So, hold on.
Let me put her question again, and I'll just ask. Yoris is asking, is it even possible to ever abolish the Reed technique? How does that work legally?
Yeah, the Reed technique, another really troubling factor in so many of these cases. I hope that more law enforcement agencies are moving away from the Reed technique. I know that I've had trials even years ago where even though this is a whole other thing, but even though the police clearly did use the Reed technique, it had been disfavored at that time, so they said they weren't using it. But I think what really makes the change on coercive tactics and coercive interrogations is, and of course legislation plays a role, right? We can make rules about what is acceptable to do when you're questioning a suspect, but really I think where the change comes is in recording every interrogation and making sure that the recording of every interrogation is available to the defense lawyer, and that the defense lawyer zealously litigates it, really works hard for their client to make sure that those inappropriate interrogations stay out. I think that once people see, and it's not always clear to the public, right? So people who are really interested in these issues are more attuned to them. It's not always clear to the public that when, for example, a police officer is not screaming and yelling and beating a suspect, that they still might be prone to a wrongful conviction. I think more education around that issue, but also just letting courts and lawyers see what's going on and having them understand it. There's actually a really good documentary about about a wrongful conviction. It's a case that I worked on as an amicus, as a friend of the court. I didn't represent the parties, but the movie is called Scenes of a Crime, and the man who was wrongfully convicted and now has been exonerated is named Adrian Thomas.
Right.
What happened to Mr. Thomas is he was interrogated aggressively over many hours by a pair of police officers in upstate New York. And what had happened was his son, who he had 7 children. The youngest were very young twins. They were under 4 months old. And one of the twins, who had been born premature and had some other health factors that are risks if you have a premature twin birth, died. He contracted this horrible infection. It spread through his lungs. It spread to his blood. And there's actually a question of whether he developed meningitis. The experts weren't 100% in accord on that issue. This little boy had a horrific infection, and he collapsed and died. And while he was in the ICU, his father was being interrogated by these police officers.
Oh,
they believed that that violence had been done to the little boy because of a doctor's misidentification of a fracture when the baby first came in. So the baby had a CAT scan when he first came in. A doctor who was not a radiologist looked at the CAT scan, concluded there had been a fracture, a skull fracture, and said, you must have done, this baby was attacked, right? So the police officers interrogated Adrian for many hours. And at one point, he expressed suicidal ideation, which I don't think is surprising for somebody whose child is dying in the ICU. And he was taken to a hospital. He was put on a locked ward overnight. He was picked up in the morning by the police, taken back to the police station, and they continued to interrogate him.
Oh, good God.
But his confession was entirely made of the facts that the cops had fed to him, right? So they had told him these things and told him that that's what he must have done. And finally he said, I did those things because he just wanted to get out of there. Yeah. What's interesting about that interrogation, which was all recorded and is part of the documentary, is that at no time, well, there's a little bit of sort of, yelling at him and getting in his face, but really at no time was anybody violent with him. There's no, there's very little even aggressive language. There's a lot of, I'm trying to help you. They put a great deal of emphasis on that he was given a drink and I think was allowed to have a cigarette, things like that. But what I think the documentary makes so clear is that it's still so coercive, right? So the police were saying, tell us what happened to him. They implied that the baby could be saved. if he confessed that he had done something violent, right? They implied that, which as a parent, let me just tell you, if something terrible has happened to my child and somebody says you can save him, just do this. I mean, I don't know what it is. I'm going to do it, you know? And they also implied that if he didn't confess, they would arrest his wife.
Oh my God. So you would, wouldn't you?
You would. And so that's a great example, right? Of and that documentary, it really talks a lot about the Reid technique. But why I think it's so interesting is that the science in it is interesting, but also it really shows how coercive an interrogation can be that doesn't involve violence, right?
Well, it sounds just like Brendan's interrogation. Just like Brendan's interrogation.
Yeah. And Melissa Kalyasinski, I don't know if you've heard of that case.
Say that because hers was a head trauma case.
And it's quite similar to what you were talking about then with the misidentification of the fracture. There's a lot of similarities.
Hey, what was that documentary called again? Because I want to watch that.
It's called Scenes of a Crime.
Scenes of a Crime, right.
I've got Linda's question back now. She's retyped it for me. Sorry about this, Linda. Right, so how much weight does the expert writing on Brendan's behalf have on the court's amicus briefs? Brendan had 250. There we go. We got there.
Every court is different. We've had cases where we filed an amicus brief and the court has ignored it. We've had cases where we filed an amicus brief and the court has been mad that we filed it. And we've had cases where we filed an amicus brief and the court has taken those facts under advisement or incorporated them into their opinion. It just varies by court.
Oh, thank you. There we go, Linda.
Yeah, I was going to mention before Brendan had an amicus brief. Just one sec.
Well,
that's we've gone through the questions now, I think.
Well, do you want to tell us a little bit about the two women who who were in the, you've been CIFS have been tweeting about a lot recently. So
we have two clients. Their names are Stephanie Spurgeon and Amanda Broomfield. We were able to secure Stephanie's release. I think it was 2 weeks ago now. She was granted a new trial by the appellate courts.
Oh no. I think you're frozen, Kate.
She might have to go back out and in again. Oh,
and
you froze then. Just as you started the answer.
It happens to all of us.
Yeah.
Well, I'll just check and make sure my connection's good.
Cool.
So Stephanie was a babysitter.
Yeah, I think you're all right. No.
You guys do.
If you can hear us, try going back out and coming back in again.
Okay.
I'll let her back in. Oh, I love technology.
It's always the same.
Oh, thanks for coming, everyone. Bye. Not really. She's back.
Yeah.
Hello.
There we go.
It's okay.
Yeah.
Okay.
Yeah, that's better.
Good. Thank you. So we represent these two women, and they're both in very similar circumstances. They were caring for children as babysitters or daycare providers, and the children died. In one case, died pretty much at the home, and in the other case, died later in the hospital after being hospitalized for several days. And so in Stephanie's situation, she was a home daycare provider, and she was watching a little girl. It was her first day watching this child, and the child had a crisis and became extremely ill while in her care. It was unusual because it wasn't immediately obvious how sick she was. In fact, it wasn't obvious to her grandmother who picked her up or the doctors at the hospital exactly what was wrong with her. So she was taken to the hospital. And she received some care, but she didn't get better, and she died. Stephanie was convicted at trial. She lost her appeal. And years later, we filed a motion for a new trial for her, alleging that she had received ineffective assistance of counsel and evidence had been brought in her trial that wasn't true. And so what we were able to show at the post-conviction hearing was that the state's theory of the case, what they had said happened, which was that Stephanie had taken this baby and slammed her against something soft so that she received internal but no external injuries. And at trial, there wasn't a witness who could speak competently to the impossibility of the state's theory. So they called a physicist who could have talked about how this was impossible, but he wasn't prepped appropriately. So the lawyer didn't really tell him what he was going to need to prepare in order to testify credibly at the trial. Then there was also a great deal of evidence that this baby was really ill and that her illness was just missed by the doctors who saw her. And that is a really sort of good example of these problems that can happen especially on a medical team, where one person makes a mistake and then the people who come after don't really, they just are not able to spot it. There's a lot of kind of cognitive bias that can happen in these kinds of decisions. So this baby was extremely, extremely ill. She suffered all sorts of problems as a result of her illness, including a blood clot in her brain and brain swelling. She died. And Stephanie was accused under this bogus theory that she had slammed this baby onto a mattress. And just, I mean, as a like complete point of clarity, this little one had not a scratch on her, not a mark, not a bruise. That was the Yeah. So many of these cases follow exactly that pattern. That's part of why we're so interested in them as an organization, because they're entirely dependent on the expert's testimony and they follow this same pattern. So Stephanie's free. So Stephanie received a new trial. We lost in the trial court. We appealed her case and the appellate court reversed her conviction. So she's going to get a new trial.
Right. And do you know when that will be?
No. We're still awaiting a number of things that will let us know when she'll get a new trial. But for right now, she's free. She's out on bond and she's home with her family, which is one of the most important things.
She doesn't have to wear an ankle bracelet or anything. She
does have to wear an ankle bracelet.
Oh, right, yeah.
But you know what? She's home with her family, and that's a big deal.
Yeah, that's the main thing. And can you tell everyone how long was it? When did you file for Stephanie?
So we filed her case in 2015. So she was waiting for justice for 5 years, but actually for longer than that because she was in prison for 8.5 years.
Oh.
Yeah. And honestly, I hate to be like super depressing, but that's one of the shorter cases.
Yeah. And how do you expect it to take to get her a new trial? How long?
So coronavirus has really thrown a wrench into all the processes. We don't know. What we hope actually is that the state realizes that she's innocent and that they don't prosecute her again.
Yeah.
Hopefully they'll do that, but we don't know if they will. And if they don't, we're ready to retry the case.
Yeah.
Yeah. Well, there's a lot of people saying well done and congratulations and that on getting her out, because that's why we all gathered together, because you know that's what we want to see, justice for people, especially in a case like that when there's a child died and somebody's been accused of killing them, like, because that was the same with Melissa Kaczynski. She was accused of slamming Benjamin on the floor, and it's just like that. Pardon me. That's a really like hideous thing to do in any way. It's a hideous thing to do. So to be accused of it, if you're not that way inclined,
right,
it's just
and there's no question that people abuse and murder children, and it is horrific. But when those accusations are based on science that isn't sound, or when experts go farther than the science allows, then that is where we're very concerned, and that can result in a wrongful conviction. So we have another client who hasn't gotten justice, Amanda Broomfield, and her case is very similar to Stephanie's. She was babysitting her goddaughter. I know. She was babysitting for her goddaughter with the goddaughter's sister, her stepson, and her two biological children in the home. And the little one climbed out of her playpen and fell and hit her head on a concrete floor, exacerbating an older injury. So she had a head injury that really nobody knew about. The suspicion is that perhaps it happened at daycare, and because especially skull fractures in little kids, are just silent. They might hurt, but you don't notice it in the same way you notice a broken arm.
Yeah. And can I just say, like, having kids, and you all know as well, Kate, you've got children. My youngest is 3. The amount of time, just even before is an incident, he fell over before and banged his head, got back up again and said he was fine. And he was, he's running around. Now, chances are he's fine. But then chances are, could there possibly be an injury and then you just like times they hurt themselves. You just saying the baby climbed out the playpen. That doesn't surprise me in the slightest, because my little one is constantly climbing out of things, and it happens all the time.
Yeah. I remember the first time I looked at my nephew, he's going to be 15 in a few weeks. But I remember the very first time I looked after him on my own, and he'd just, when they just start running around, they're at that tiny age, and they're just starting to run. So they've been walking, and he ran into me in the kitchen, and he went thump off the door frame, and a big egg lump came up on his head, and I was like, oh God. But kids get that, don't they? They've bought bumps and bruises and scrapes and stuff, but you're just like, oh. And to think that they can have an accident like that, and then
when they're little, they're good at getting going and not good at stopping.
Yeah. Oh.
Yeah. So she was babysitting her goddaughter, and her goddaughter had this terrible injury, and very similar to what you're describing. She seemed all right.
Yeah.
For a little while. She seemed all right for maybe about half an hour, and then she fell asleep, and it seemed like she just fell asleep because it was the middle of the night. She'd climbed out of her playpen, she bonked her head, and she seemed okay. And poor Amanda thought she was, just tired. And it turned out she had this bad injury. So I see that somebody's got the petition for clemency. Yeah. So we've
everybody go and sign it.
Yeah. So we're not only fighting her case, asking for a new trial in court, we're also pursuing this avenue of clemency, asking the governor to grant her clemency because she's innocent. So we're fighting that case on 2 fronts.
Oh God, I hope someone listens. How awful that it just cases like this with kids. I get really emotional about it.
It's so unfortunate, the evidence that was presented in her trial. It's really an injustice. It's really disappointing that that doctors at her trial who testified for the state said things like a toddler, a 1-year-old toddler couldn't climb out of a playpen.
As if.
That is absolute rubbish.
Like a Skype artist, isn't they?
Told. He just used to shimmy. He used to shimmy over it.
Yeah.
That's rubbish. Absolute rubbish.
Yeah.
Rubbish.
That's pretty much the motion we filed, right? We said that's nonsense. That's absolutely wrong. And that shouldn't have been presented at her trial. The jury never should have heard.
I'm going to testify and say my son's done it.
Yeah. You'd have many people coming.
Oh God, I can't believe that is what was presented.
Not to sound
presented.
I'm sorry.
Was that all that was presented, or was there what else was?
No, there was a variety of other stuff, right? So pathologists so the pediatrician testified that the kind of injury she had wasn't consistent with falling out of a playpen, and that he didn't think she'd be able to climb out of a playpen anyway. And then pathologists testified that the kind of injury that she had was not consistent with the fall that Amanda described. But of course, both then and especially since then, there have been other scientific studies that have been done looking at kids who had very similar injuries from very similar falls. And so it's really now known to be untrue. We've also alleged that in that case that the lawyers should have presented an engineer or physicist to talk about the kind of fall that the baby likely experienced.
Yeah.
How fatal.
Oh gosh. Well, make sure everybody go and sign the petition for and if we'll keep sharing that on Twitter.
Yeah, absolutely.
As much as we can, because that's just terrible.
Well, one of the other links that we wanted to share as well, because obviously CIFS, they run on donations, right?
We do.
Yeah, so I've shared the link in the description as well for people to go and donate to that, please, so that you can keep doing the amazing work that you and the team there are doing. So yeah, thank you so much for joining us today. It's been an hour already, we've been chatting.
Thank you for having me. We're so grateful for everything that you're doing and advancing the cause of remedying wrongful convictions. And we certainly appreciate and gratefully accept donations from the public. But I know it's a really hard time for people. And if you can't give, you can really help the organization by doing things like sharing our website, sharing our social media, signing the clemency petition for Amanda. You can really help us in those ways too.
We'll definitely be doing that. Eric's just asked, is Kate on Twitter? And she is. All the information is in the description. You'll be able to find different links to the CIFS and to Kate as well. Are you on Instagram, Kate? I don't know.
We are on Instagram. I think it's just @justice.
Oh yeah, I've put that in the description as well. Yeah, okay.
I don't have a personal one.
Oh, that's fine. I've shared all of those in the description anyway. So thank you so much for joining us, and thank you everyone who's come to watch it today. Don't forget to share all of the donations, the clemency petition, like, share, and all that sort of business. Yeah. And good luck with Amanda and Stephanie. We'll be keeping an eye on that for sure.
Yeah.
Thank you for having me.
Hopefully we can have you back to talk more about if Stephanie gets a new trial, or if you're allowed to do that, or come on and speak to us about that. We'd love that.
I'd love to do that.
Yeah. Oh, brilliant. Well, thank you.
It's fine with me.
Oh, brilliant. Thank you.
Well, thanks. Well, bye everyone.
Bye everybody in the chat.
So much.
Thanks for coming.